When you're served with a domestic violence restraining order, it can feel like your entire life is collapsing. You might be told that you can't go home, that you can't see your kids, or even that you can't see your pets. It's more than just upsetting. It's more than just a legal crisis. It is a personal crisis. But on the first page of that stack of papers that you were served with, there's going to be a court date listed. It will be 21 to 25 days out from when the other person, the petitioner, made the request. And you might think, okay, great. At least I'll get to tell my side of the story. At least this suffering that I'm going through is only going to last about 3 weeks. But here's the reality. Most courts are not going to be ready to hear your case on that first date. And sometimes they may not be ready to hear your case on a second court date, which could be weeks or months later, or even a third court date. This is, understandably, very frustrating. I've seen many people get blindsided and make a terrible impression on the judge because they are so shocked and devastated. So let's talk about how to deal with this. I'm going to walk you through exactly what to do and even give you a script that you can print and bring to court with you as a cheat sheet so that you are prepared to push for the soonest possible hearing date, hopefully that same day, in an effective way. And if the hearing is going to be continued, potentially get visitation if children are involved in the meantime, while making a great impression on the judge, because the judge is ultimately the one who decides whether to issue a restraining order for up to 5 years. Make sure to watch until the end because you are not ready for your hearing unless you know all of these steps. My name is Veronica. I'm a domestic violence defense attorney, and I help people throughout the state of California put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself at a restraining order hearing and win. So if you're watching this video, you have a restraining order hearing coming up, make sure that you get your free first class in the course via the link down below. Okay, so let's jump right in. The law, specifically Family Code Section 244, says that the court has to give older restraining order hearings priority over everything else on the court's calendar first. But most people, if they represent themselves, don't know that. And courts are used to just pushing your case out to a date that is convenient for them. So let's go through 5 steps of exactly what to do and say in court if the judge or the other party tries to reschedule the hearing for a later date, so that when you show up for that first court date and the subsequent dates, if there are any, you are prepared and you make a positive impression on the judge. Step 1. First, before you step into the courtroom, try to figure out how many older domestic violence restraining order cases there are on the court's calendar. Check the list of cases, generally called the calendar, which is usually posted outside the courtroom, that are set to be heard that day. You can also find this online in most counties in California by looking up the calendar for that particular courtroom. Now, when you are looking at that, you're looking for 2 things. First, you're checking to see how many cases are actually domestic violence restraining order hearings. Most DVRO courtrooms are general family law courtrooms. That means that there are all types of hearings on the calendar. There might be requests for orders, aka RFOs, ex parte application, trial setting dates, all kinds of different things on the court's calendar. DVRO hearings have priority over those cases. All of them. Does not matter how old they are, when they were filed, DVRO hearings have priority. Now, obviously, this is inconvenient for the judges in the courtrooms because they are trying to figure out divorce financial matters, hear motions from parties about custody, things that are actually important to people. But the law says that, too bad, DVRO hearings have priority. So we're checking that first. Second, check to see how many DVRO cases are older than your case. You can tell this by looking at the case number. Cases are given numbers in chronological order. In many places, they will have the year first, 23, 24, 25. Okay, so look at that. Then there will usually be some letters or there will be a dash, and then there are additional numbers. So see in chronological order which case is older, and make a mental note or jot a note to yourself. So make a mental note of this or jot a note to yourself. This will help you be prepared mentally for you to know what to expect. If there are 20 DVRO hearings older than yours on the court's calendar, that's not a good sign, because although many of those hearings will not go forward, especially if it is their very first hearing, often petitioners have not served the respondent, sometimes people don't show up, at least some of them probably will. And I know that this does seem like maybe a little too much, but this is the type of preparation that we go through in the Defeat the DVRO course, where I help people like you get ready step by step. And it is what I do as an attorney because I want to know whether my hearing is likely to go forward. Step 2. Once you get called in front of the judge is likely going to ask if both parties are ready to proceed. A lot of people will say no. And that makes it easy for the judge to make their calendar and their day easy by setting another hearing date. But say yes, assuming that you are, and be ready. Take the free class and Defeat the DVRO, take the course, spend a weekend preparing so that you can say yes, because otherwise you risk, and it will be your own fault, weeks or months that the temporary orders stay in place and you do not even get to tell your side of the story. And it might be continued again after that. If the petitioner answers no, that they are not ready and asks for more time, then here's what to do. And this applies to any court date, including the first one. Family Code Section 245 says that while you, the respondent, you get one continuance if you want one, the petitioner must show good cause for a continuance. It cannot just be that they are not ready. So if that happens, if the petitioner says that they are not ready, here's exactly what you say. And this is all going to be in the cheat sheet that I list down below, so you don't need to take notes, but the cheat sheet just has the scripts. You do need to watch the rest of the video to understand. So here it is. Your Honor, I am ready to proceed. I would object to any continuance. I don't believe that the petitioner has demonstrated good cause for a continuance. And then stop talking. No matter what the petitioner says, don't argue. Don't get into the petitioner says they're going to hire an attorney. Well, they should have hired one by now. Don't get into the petitioner's witnesses aren't ready. Well, they should be here, or that person doesn't know anything anyway. Don't say anything. Don't get emotional. Let the court do its job and evaluate whether or not the petitioner has demonstrated good cause. Now, the judge might then tell you that even though you're ready, and even if the petitioner has not demonstrated good cause, or maybe the petitioner said that they're ready too, that there is not enough time to hear your case that day, and your case will have to be continued, meaning set for another day, meaning you do not get to go forward that day, and meaning that in the meantime, generally, unless, and we'll get into this in the later steps, all of the temporary orders, that you cannot go home, that you cannot see your kids, that you can't see your pets, you can't get your stuff, all of that is going to remain in place. And here's the thing, the judge is probably booked for at least the next few weeks. Sometimes there's a calendar on the wall, and you'll see a bunch of dates are X'd out, a bunch of dates are marked with different colors, probably for the next few months. And the judge will probably propose a day weeks or even months out. This is when you will pull up your handy printable cheat sheet and say, Your Honor, as the court knows, under Family Code Section 244, our case would have priority over any other matters except older DVROs. I understand that the court is very busy today, but would it be possible for us to wait to see if there's time after the older DVRO matters are called for our case to be heard? What you are asking there is to wait around at court to be heard after those older DVRO cases that you saw on the court's calendar. Now, the reason why you're asking this is because some of the older DVRO cases might settle, especially if they have not come in front of the judge yet. They might settle and maybe the judge doesn't know it yet. The parties in those cases might agree to a continuance, in which case their cases will get continued. The petitioner might not show up and the case might get dismissed. The judge knows this, and that is exactly what you are referring to. At this point, the judge may speak with the clerk. They may talk about what other cases are on calendar. They might ask you to sit back down, and maybe they'll call you back up later because they do want to see what happens with those cases. If that happens, that's good. You've shot your shot, at least for now, to try to actually have the hearing go forward that day. Step 3, have a time estimate ready. At some point, the judge might also ask both of you how long your case will take. Your portion of the hearing, really, if it's just you testifying and showing some evidence by yourself, should take no more than 30 minutes, and many judges will not even give you that long. Possibly it's longer, especially if you have videos and you need to show the entire thing, but generally, 30 minutes is going to be about what you would want to say here. Do not cut yourself short because the judge will hold you to this, but also not give the judge an overly inflated estimate, because the shorter that your hearing time estimate is, the more likely that the judge can fit you in that day. You would say something like, Your Honor, my portion of the case should take no more than 30 minutes. Step 4. If the judge says no, keep calm and ask for what are called interim orders. Be prepared for the judge to say no to having the hearing that day, even if you are willing to wait around. The judge might also say that the petitioner can have a continuance depending on what their reason is. So let's talk about how to handle that. The judge knows that this is very frustrating and very difficult for respondents, especially when housing and child custody is involved. There are a lot of respondents that I've seen over the years, they lose their cool. They get really frustrated. They really thought that, okay, I suffer for a few weeks, but I get to come in and tell my side of the story. And they've now been told that that's not going to happen. This is your chance to not be like them and to show the judge that while the other side is probably trying to paint you as this out of control abuser, you have control of your emotions. You can slightly nod in understanding or just wait. Don't react. And then ask for interim orders. Interim orders means that instead of those temporary orders remaining in place and staying exactly the same as they are, saying that you cannot go back home, that you can't see your kids, pets. Sometimes there's possession of, your only vehicle or both vehicles, something in there that causes a big problem for you. You're asking for those orders to be changed. When there is an opportunity, do not interrupt the judge. If you have no visitation with your kids during this time, you can say, Your Honor, would you consider allowing visitation in the meantime? I'm concerned about the impact of no contact on our child. Always say our child. If you're new to family law, do not say my child, ever. Do not say my children unless it's only yours and not the other parties, child with somebody else. You have to say our children always. Anyway, saying it this way shows the judge that you are reasonable and focused on the best interests of your kids. Many judges are reluctant to issue temporary orders because all they have in front of them at this point are these allegations that you are this abuser. Not necessarily to your kids, but even abuse to the other party causes this presumption in family law that it's not in the best interest of the kids, that it's not good for the kids for you to have custody or visitation. And the judge hasn't heard evidence yet. It's not your fault. You want to give the judge evidence, but they're not hearing it that day. So one way that you can sweeten the pot with the judge and make the judge more likely to at least let you see your kids is to propose supervised visitation. Now, I know nobody's enthusiastic about this, but at least you get to see them. This is where a professional monitor is there for the visitation and the drop-offs. This is reassuring to the judge because no contact would be needed between you and the petitioner during exchanges. And there's a professional there to make sure that nothing goes wrong during this visitation. Now, my suggestion, if this is something that you are thinking that you want to at least have in your back pocket, is to find a court-approved professional monitor in your county and confirm their availability in advance and think of a schedule that would potentially work. Usually it's just going to be a few hours on a weekend day if your kids are in school that you would see them with this professional monitor. And I know it's not ideal, but if the judge is not otherwise inclined to allow you visitation and custody time. If you're going to go with this, then you would say, Your Honor, I've already confirmed that the monitor's name is available to supervise these visits. I propose supervised visitation on day of the week from whatever time to whatever time. By doing this, you're showing the judge that you're not trying to contact the other party, because unsupervised visitation usually means some sort of exchange. And especially if neither of you has an attorney, you cannot go through your attorney, so that's going to be a concern to the judge. You've arranged everything in advance, which is way better than most people who have attorneys or don't have attorneys. And you're showing the court that your focus is on safety, that you can follow boundaries, and doing things the right way. Making it easy for the judge to say yes to you is one of the biggest things that I emphasize in Defeat the DVRO. The judge may say no to visitation, supervised or unsupervised. Again, every time that the judge says no, and the judge knows you want this, you've asked for it, and the judge is telling you you cannot have it. If you stay calm, cool, and collected, you're doing much better than most people. And remember, the restraining order is very likely all about how you do not stay calm, cool, and collected. So you are helping yourself out for the future for when you do have the hearing here by making a positive impression on the judge. And you'll be an outlier. The judge may have a lot of cases, but judges do remember outliers. And whether or not there are kids involved, if the restraining order is interfering with your job, like maybe you can't access your car or tools for work, something like that, you can ask the judge for a limited modification there. Your Honor, under the current order, I cannot get my work truck, which is at the house and has all of my tools. Would you consider modifying the order so that I can access the truck and use it until we have a hearing on this? Look, again, the judge may not say yes, but it's okay to ask, especially if it's preventing you from earning income. Step 5, ask for the earliest possible date. Now, let's say that the judge gives you a new date. Often the first date that they propose is going to be weeks or often months away. At that point, here's what to say. Your Honor, I'd respectfully request an earlier date if one is available. I'm willing to wait that day. You're reminding the judge that you know about Family Code Section 244, and you're referencing it here without being argumentative. You're being very professional about it. And if you have a child and the judge said no to visitation, then add, I'm concerned about the impact that this delay will have on my relationship with our child. I want to resolve this quickly so I can be involved in our child's life again. Sometimes this will cause a discussion between the judge and the clerk where they really try to shake down the calendar and find an earlier date for you. But if the judge says no, this is truly the earliest possible date, just nod, stay calm, and accept it. You're not agreeing, you are demonstrating understanding. That moment, again, is part of your presentation to the judge. The judge does not know you. The judge sees genuine abusers all the time. You are showing you are not one of them. And if the judge gives you a sooner date, don't say that it doesn't work for you. It doesn't matter what you have going on, then clear your schedule. Make it work. If you follow these steps, you've just made a great impression on the judge. You've stayed calm, you've demonstrated that you are prepared, and that you are respectful. You've shown that you care about your children if you have them, that you understand the laws, nobody can just pull one over on you, and that you're not there to play games or air all of your grievances about the other person, and you have effectively advocated for yourself. If this happens at a second or even third court date, rinse and repeat. Keep following these steps. Do not deviate. Do not get frustrated, or at least don't show it. And keep your cheat sheet handy. Remember, you can download it via the link down below. And remember, this same judge may be the one deciding very important issues in your life. If you have kids, custody, divorce, property, for everybody, the DVRO itself, how you show up matters. The judge has to assess you as a person in a very short amount of time. Look, the law is not intuitive, as you are probably starting to see. A lot of people who don't realize that, who just show up for their court date unprepared, may not be abusers, but the impression that they make on the judge and the outcome that they get is as though they are. The law is not rocket science, but you need to know what it is, and you need the right tools, which is exactly what I give you in the Defeat the DVRO course. When you are learning something new, to me, one of the hardest things is that you don't know what you don't know. So in the course, I teach you from start to finish everything that you need to know to present your case, represent yourself, and have your best chance at winning. So go take your free first class at defeatthedvro.com. You have literally nothing to lose, and you can do this. People who've taken the course email me all the time telling me that they followed the steps and they won. They didn't have a lawyer, but they did it themselves because they knew exactly what to do. I hope you found this video helpful. Make sure to like, subscribe, ring the bell, and if you have a question or comment, leave it in the comments.